proceed.
Thank you, Senator Tucker. Members of the committee, my name is Joey McCutcheon. I'm a co-founder of the Arkansas Transparency and Government Group and have given a significant portion of my time to defending the Freedom of Information Act in legislature and also as a practicing lawyer. By the way, 90% of that time has been on my own dime because people, everyday working people, can't afford to hire a lawyer to try these cases. And that's sad, and I'm going to talk more about that. I do want to thank the Senate for doing away with the deliberative process exemption. I'll thank each and every one of you for that. We don't want to be like the federal government. I don't want to be like New York or California, a federal government that uses that exemption over 81,000 times in 2013 and has used it over 60,000 times every other year. And that's secrecy, and that's not good. And maybe that's why we have some of our problems on our federal level. So thank you for what you've done in that regard. But I learned as a pretty young kid, I think, from my mother that if it walks like a skunk and it smells like a skunk, it's a skunk. And so we've still got a smell in this bill. And I want to talk about that. And I heard the last speaker talking about process. You know, we didn't have to spend yesterday waiting around after amendment, because this body created a FOIA task force. You all are familiar with that. A FOIA task force that vets FOIA bills. There's several people who have spoken who are on that task force. And unfortunately, this bill did not hear from the sponsors from the task force, and although we had a meeting yesterday morning which would have vetted many of these issues, because words matter. And as Senator Tucker said on these cabinet discussions, words matter. When we use in Section 29, records reflecting communications, that needs to be abundantly clear, because with all due respect, our governor's not going to be here in the future. Senator Hester's not going to be here. So the only thing that's going to get resolved, we just can't trust you that that's what this says. So that's what the purpose of a FOIA task force is. But I want to talk specifically about how I believe that what legislators need to really reflect on that's left in this bill, and Senator Tucker hit on that, and it's the attorney-client privilege. You might call it the CC your government lawyer exemption, because as much the bill you got rid of, the exemption you got rid of, I think you weren't here, Senator Johnson. I want to thank you for that, the deliberative process exemption, because it's been called the most abused exemption in the federal government. And also, this attorney-client privilege can and will be abused. There is no question. If a state agency, commission, board, we've done some research, and there are somewhere to the tune of 334 of those bloated government, should I say, in Arkansas. So what we're going to give them is the ability to CC your government-paid lawyer, or include your government-paid lawyer. When there's something embarrassing, illegal, or unethical, then CC your lawyer, CC the government lawyer, and this will never see the light of day, and that's concerning. I mean, I hope that you can see. Yes.
Whenever you say this will never see the light of day, what are you speaking to?
What I'm speaking to is, let's take one example of what I'm speaking to. I'm speaking to Jerry Sandusky. I'm speaking to the assistant. No. Let me answer your question.
Hey.
I want to answer your question.
I'm the chair. I ask you specifically, what are you talking about whenever you said this? That it's unclear as to what you're referring to, not an analogy
okay.
Just tell me what you're talking about. This will never be discovered.
Sexual abuse of minors, government waste and fraud and abuse. Because if there is that, and there's documents out there that the public's trying to get, all a government bureaucrat, one of these 334 agencies, all they have to do, if there's wrongful conduct, is include the lawyer in that. And we can talk specifically, Senator Johnson, about, let's look at Section 31 of the bill, which says that records created or received by an elected or appointed state officer, a state employee, a state board, a commission that would be privileged under Rule 502B of the Arkansas Rules of Civil Procedure. Why don't we can also call this amendment, using the attorney-client privilege, as the Mack truck exemption, because anyone who wants to hide government abuse or some other abuse will include their lawyer under Arkansas Rule of Evidence 502B, and that is a broad exemption, as Senator Tucker has talked about.
So that would not be FOIA-able any longer, right?
That's correct.
And what is that would not be FOIA-able?
That would be all records, emails, text messages from government agencies that they CC to their government-paid lawyer. That would be all of those type communications that could not be disclosed to the public. And that is, Senator, that is a very, very broad and troublesome, and one that could clearly be abused. And I think it's what's left in this bill that citizens should be very concerned about. And I think it's one of the pieces that citizens are concerned about. And I wanted to get to my example that I just talked about. Pennsylvania had a very broad exemption just like this one. And Jerry Sandusky was the football coach and assistant football coach at Penn State University. And he abused young person after young person after young person. And they used this exemption to keep out of public's eye what was going on. And that could very well happen here. Senator, I used the Freedom of Information Act in a case recently because I try a lot of these, and you probably heard of it at Huntsville, Arkansas. I used the Freedom of Information Act to get emails regarding sexual assaults that were occurring on our young people. And when I look in the eyes of the mother of a youngster who was abused time after time in a locker room, and then I'm able to see what FOIA can do, that's important. That's extremely important. And it can happen on the state level just like we saw in Pennsylvania. So
on a personal, outside of government level, how do you get those documents if you don't, in a personal business, if you're an attorney and trying to fight or prosecute somebody or put them in a lawsuit? How do you get those informations without FOIA? Whenever you're in a regular trial, not against government, against a regular individual, how do you get those information?
Well, look, I was asking for, when the parents contacted me, I was asking for those records, those communications regarding these sexual assaults before the lawsuit was even contemplated, so that the parents could get some sort of closure and find out what was going on.
Mm-hmm.
Did that answer your question, sir? I may have.
I'm talking about in a regular suit, how do you get the information that you're requesting through, that you would get in FOIA in the state of Arkansas?
Well, in a lawsuit, I mean, clearly we have discovery that we're gonna get records, but look.
So you want to use the FOIA system to circumvent discovery?
Well, sir, you're conflating and you're confusing two separate issues. I'm not talking about the work product privilege here. I'm talking about attorney-client privilege here. Mm-hmm. I don't want to do anything. What I want to do is for the public to be able to scrutinize what government is doing. And I don't want a lawyer to be CC'd by a Jerry Sandusky type and then the public not be able to see that. And you know what happens then? It might be one of our children that is being sexually abused, because this conduct went on for 2 years. Again, that was on a local level, but we can certainly see that it can occur on a state level. And that's just take Ecclesia College. Take the abuse that we saw people go to prison for 17 years. What about those documents? Just put a government lawyer. So this is. I asked you a question. If we did not have Sarah Sanders as the governor, and maybe it was a Gavin Newsom type, would you be a little more skeptical about this bill?
I'm comfortable. I'm comfortable, sir.
And I appreciate that. I appreciate that.
I think it's a matter of efficiency in government, and I appreciate it.
Well, when efficiency in government is a code word for weakening FOIA, I'm not.
Don't put those words in my mouth.
Well,
I want the transparency in the FOIA, and we have worked hard to keep a large part of transparency. But a government should not be usurped through FOIA in suits. That's just my opinion. So, Senator King, you had a question?
Your sample of the Huntsville school situation is spot on about abuses and we have other. We're talking about families. The governor, and we're all concerned about that, but we should be concerned about other families and the abuses that happen. I mean, I can remember the U of A Foundation scandal when Chancellor Gerhardt tried to hide the records in personnel. I mean, the idea that we're going to go through this, like I said, the transparency part. We don't know what we don't know, and we don't know the situation that's going to happen. They're going to know that, and many times, would you agree that, government lawyers that represent a school board are still paid by our tax dollars? This idea that this is like a civil case, it doesn't apply, because we're still using the parents of the one situation. We're paying tax dollars to these people that were trying to cover up the sexual abuse. So this idea, this civil thing in government, is two different things, and our founding fathers were pretty clear about that, about how government is different.
Sure. Our founding fathers said, and I want to quote my hero, Patrick Henry, when Patrick Henry said, "The liberties of the people were and never will be secure when the transactions of their rulers may be concealed from them." And the transaction of our rulers and our 334 state agencies can and will be concealed from us, Senator King, when they notify their government-paid lawyer. Yes, you mentioned lawyers, and I want to talk about attorney fees, because one of the things I don't see in this bill is attorney fees restricting the high-priced government lawyers, the ones, for example, in Huntsville that charge $29,000. But I want to talk about a case, and I want to say this before I do this. FOIA is not a conservative issue, and it's not a liberal issue, and it's not a Republican issue, and it's not a Democrat issue. It's a freedom issue, bottom line. Patrick Henry said it best. I want to talk about Isla Campbell versus the Fayetteville school system right now. That's a case where Isla Campbell sent a FOIA request to the Fayetteville school system asking for documents related to critical race theory. She sent the document twice, and they claimed that it was not clear. She then called me and said, "Why don't you try your hand at drafting one if you want to?" And I said, "I'll do it. I sure will." So I drafted one. She sent it to them. And, they sent back the same response that it's just not clear. So what we did, we filed a lawsuit, Senator Johnson, and you know what? 2 days later, you know what Fayetteville did? They produced about 10,000 documents, of which this courageous lady went through every single one of them. We had a hearing on that. She did learn that there's critical race theory going on, which is an issue that I know that Republicans in this body are concerned about. Again, this isn't about Republican or Democrat. It's about freedom, in my opinion. But so we got those documents. So let's talk about attorney fees. Isla Campbell, like everyday citizens in this room, probably can't afford to pay a lawyer $200-300. Again, I'm not looking for a buck when I try these cases, but what I was told is you need to start collecting an attorney fee because you know what? That's the only teeth that FOIA has. It's the only teeth. Ms. Campbell, at the end of that, they turned over the records and we were able to collect attorney fees because we substantially prevailed. However, you know what the arguments of the Fayetteville lawyers were, the ones as Mr. Steinbuck talked about, the ones they hire outside, they hire the big silk stocking law firms that charge no telling how much. We know a little how much they charge, but the judge did award attorney fees in that. But the question would become, would the judge award attorney fees if we had this bill? Probably not, because they would make the case very persuasively, as good lawyers do, that the defendant's conduct and the denial of these 10,000 or so records was arbitrary and bad faith. They would say we were not arbitrary and we were not in bad faith.
Is that an assumption that you're putting on the judge?
An assumption?
Yes.
It's an assumption that I am, based upon my experience of trying these cases, is that based upon this law, attorney fees would not have been awarded in that case, and they will not be awarded in most other cases. That's your opinion and your assumption. All of these are my opinions, right. and all of these are my opinions, sure. But we need to understand, in my opinion, and we need to comply with what the intent of the 1967 law was. And it said it's vital to a democratic society that public business be conducted in an open and public manner so that we can see the performance and the decisions of the folks we've elected. And I think that should be the gold standard for which this legislation is evaluated. And I hope that you will limit this bill and not let with respect to state agencies, 334 state agencies, boards, bureaus, I would hope you would not let this exemption gut our state FOIA law, because I think that's exactly what it does.
What exemption?
The exemption that I've talked about, the attorney-client exemption, just CC your government lawyer, and the public's not going to see anything, and we do our business in public. That's outside of the intent of the 1967 law, and quite frankly, I think Winthrop Rockefeller's rolling over in his grave right now that his fellow Republicans.
What was the Congress? What was Arkansas Congress whenever that got passed? It was not Republican.
That's exactly right. A Republican governor who said this was a crowning jewel of my administration passed a transparency law with Democrats like my good friend Clark Tucker, and that was impressive. And it's been intact since 1967, and how important it's been. We've had our stumbles with corruption, but I can assure you, you turn government bureaucracy, 334 boards over just let them see their government lawyer, we'll see an increase in corruption. And most government officials are honest, ethical, straightforward people, but there's always bad apples. And this is, and I'll close. This law
You're
is a,
still in question.
I'm sorry?
You're still in questioning.
I'm sorry about that.
Go ahead, Senator Dodson.
Thank you, Mr. Chair. So I've heard you say a couple of times referring to Sandusky and the criminal behavior there. And as I understand it, of course, I haven't studied the specifics of that case, so I can't speak as I'm an authority on it or by any stretch of the imagination. But as I understand it, and I've received communication that Penn State was exempted under their state FOI law. So it's a completely different scenario than what you're talking about. Just in general, it wasn't covered under that at all.
No, not in general. No, they were covered by a broad exemption that exempted this type of conduct. So no, not generally. It was not.
Well,
So-
I'm saying I can't speak to the specifics of the case.
Okay.
I'm just putting that there as far as context on what you're talking about.
And they changed the way they were doing business in 2008, and they tightened up their exemptions, and they made
Okay.
government more.
Hold on.
Sure.
More specifically to the attorney-client privilege is what I'm going to talk about. And I was just leading up to this because I read the 502B portion that refers to attorney-client privilege. I'm sure you're fairly familiar with it being an attorney. But as I understand it, the 8th Circuit 1984 U.S. versus Horvath said the attorney-client communications lose their privileged character when lawyer is consulted to further continuing or contemplated criminal or fraudulent scheme, not solely with respect to past wrongdoing. So as I understand attorney-client privilege, it wouldn't cover illegal activity.
Yeah, you understand it wrong, I think.
So if you have a client as an attorney,
Yeah, if I have a client like Jerry Sandusky who comes to me and said, I've abused child after child, I don't think that I'm going to run out and be telling everybody about that. And I think that hits at the heart of the attorney-client privilege and the trust they have in me.
okay. I don't have any other questions.
So as someone would know, I don't know about Governor Rockefeller turning over his grave. I do know my family members that supported him back then, and some of them would turn it over their grave with this. But so if you ask the question of the governor's staff, they email a agency head, secretary, whatever, and a legislator, then that's not FOIable. The way I understand it, it is. Do you think? I think this is a question we need to really have answered, and we just don't have enough time to answer it.
Well, we have enough time. We've had enough time. If this bill would have been brought transparency, just like the tax bill was, the tax cut bill, this bill could have been vetted in the FOIA task force. We wouldn't be going through, as the last speaker said, this dog and pony show. So yeah, if this bill could have been vetted, this is the most important, in my estimation, in my opinion, this is the most important piece of legislation that's come before this body because it hits at the foundation of our democracy. If we don't have the right to know, we lose our freedoms. And you understand that, Senator King. We lose our freedoms. Knowledge is power, period.
Well, and I think that, like I said, this bill is for a special session. In my experience, it should have been filed a month ago where we can vet it and have time. This is just too quick. And I think if you look at the aspect of what we've had in previous years that I even know of, the idea that a governor's staff can email a secretary, include a legislator, and then all of a sudden, and then maybe that legislator's a lawyer, no offense. I mean, this just opens up everything. I mean, just look at our past few years here about what's happened. This is just a dangerous precedent on this that has nothing to do with the governor's security.
Well, I would agree with that I don't think this bill's about the governor's security. I think we all agree that the governor's security is paramount and important, but I particularly think that we should be able to see the governor's expenses If she's flying on a government-paid airplane, I want to know exactly how much she may be charging the taxpayers. I want to know if she's flying around with a political consultant. I want to know who's with her. I think those are fair things, and it's just not this governor, because as we all know, and I think this is an important point, the next governor won't be someone that we respect greatly like Sarah Sanders. The next governor may be someone we don't, and who would maybe not. We might want to look at that, and we should be. We should have the right to know.
Senator Tucker?
Thank you, Mr. Chair. Mr. McCutcheon, you know how many no votes there were in that FOIA bill in 1967?
Zero?
Zero. What I want to make sure that one thing is clear, because it's a very important point, in my opinion, and there were some questions between you and Senator Johnson about it. There's two exemptions relating to attorney-client communications. The first one has to do with a litigation context, correct?
Correct.
And the second one has nothing to do with the litigation context, and that's what Courtney Kennedy from the governor's office confirmed during her testimony this morning.
That's correct.
Right. So what I want to make sure that the members who are here in the room and others who will be voting later understand and is clear is in a civil context, there's no discovery outside of litigation.
Right.
So there's no way to get those communications, even ask for those communications outside of a litigation context, right?
Correct.
So what you're talking about and what my larger concern is subsection 31, which I think you have aptly described as the CC your lawyer text. And so that's applicable even when there's no lawsuit pending.
That's right.
Yeah. All you have to do, in my experience in litigation, when a privilege log is produced, there's a to line, a from line, and a CC line. And so long as the lawyer is just merely copied on the email, it's listed on the privilege log, and I've never personally seen a judge compel production of that in discovery.
Just won't happen. You know, and what's going to happen is there's going to have to be more expensive lawsuits. But I want to thank the Senate also for, and it's probably what was happening yesterday, but which should have happened in the task force a month ago, a public body, by the way, one that the legislature created. I want to thank you for at least taking the time to define what anticipation of litigation is and putting some parameters on that. I think that that was important, and I think. But we have to understand that there's a difference. I heard Senator Hester use this playbook analogy. Well, we can't give up our playbook. Well, there's a difference between Joey McCutcheon getting the playbook of another private lawyer and Joey McCutcheon, the lawyer, getting the playbook of a government lawyer. And that's the key. The public has the right to know. And that's what the legislative intent said. So, my opinion is that you should amend out the 1967 legislative intent if we're gonna pass this bill. Just do away with it too. Do away with the legislative intent, which said that it is vital to a democratic society that public business be done in an open and public manner, because this is that exception.
Mr. McCutcheon, that is very broad and beyond this bill.
No, sir, that's not beyond this. I disagree.
I'm fixing to release you from comments.
Well,
that is beyond this bill, what you just said.
No, sir.
No, sir. No, sir. It is beyond this bill. What you're referring to.
I'm referring to the law, sir. That taught the entire legislative intent of this law.
Legislative intent of 67.
Yes, sir.
It's beyond the scope of this bill. I appreciate your comments, and you are excused. Thank you.
Well, thank you, Senator Johnson. I appreciate that, and I appreciate the committee for hearing me and hearing my comments.